time, we will now introduce the panel that is going to be a part of the role of industry stakeholders. So first, we have Kenia Nottage. Kenia Nottage currently serves as a consultant in the Office of the Attorney General of the Commonwealth of the Bahamas. She formerly served as a legal officer at the Caribbean Community Secretariat in Georgetown, Guyana, and legal attaché at the Bahamas High Commission in London, United Kingdom. She is the third vice chair of the CARB Bahamas branch and is CARB Bahamas' representative on the Bahamas Financial Services Board. Gowon Bowe is the Group Chief Executive Officer for Fidelity Bank and Trust International Limited, including its publicly traded subsidiary, Fidelity Bank Bahamas Limited. He is a former partner and advisory leader for a Big Four accounting firm and has been responsible for some of the largest audit and consulting engagements for private and public sector entities. He has been the recipient of several academic awards and serves in numerous leadership capacities with numerous civic organizations in the Bahamas and the Caribbean. He is a regular presenter, facilitator at seminars and training sessions, as well as a speaker at business accounting related discussion forums and media programs. Khrystle Rutherford-Ferguson currently serves as the first female chairman of the Bahamas Chamber of Commerce and Employers Confederation. By appointment of the Prime Minister of the Commonwealth of the Bahamas, Mrs. Rutherford-Ferguson also serves on the Economic Recovery Committee, which is charged with developing strategies and recommendations to assist the country in its economic recovery due to the COVID-19 pandemic. Mrs. Rutherford-Ferguson also serves on the National Coordinating Committee on COVID-19. She is an attorney at law and heads the legal department at Fidelity Bank Bahamas Limited. Kahlil Parker practices law as a partner in the firm of Cedric L. Parker & Co. He is an accomplished litigator and appellate lawyer and has appeared before the Supreme Court, Court of Appeal, and Privy Council. Mr. Parker's areas of practice include civil and commercial litigation, banking and financial services, law and policy, corporate governance, industrial relations and employment law, public law, and judicial review. Mr. Parker presently serves as president of the Bahamas Bar Association and has been a director of the Bahamas Agriculture and Industrial Corporation, a member of the Rehabilitation of Offenders Committee, a member of the Fiscal Responsibility Council, and executive board member of the Bahamas Chamber of Commerce and Employers Confederation. Lorna Longley-Rolle is legal counsel and secretary to the board of the Insurance Commission of the Bahamas. She joined the commission in 2010. She is also responsible for the oversight of its legal department. Mrs. Longley-Rolle commenced her public service career as a professional teacher and later transferred to the administrative stream, serving in the immigration and foreign investment departments. Following her call to the Bahamas Bar in 2005, she served in the chambers of the Office of the Attorney General. Her current role includes oversight of policy and enforcement matters pertaining to the regulation of insurance in the Bahamas. These matters also include the administration of an arbitration tribunal as an integral part of the Commission's role and function. Odecca Gibson is an attorney by profession and legal counsel at the Securities Commission of the Bahamas, and she has gained wide experience in both the public and private sectors. Mrs. Vandera Woods-Carey is an attorney at law with over 10 years of experience in the legal practice. Mrs. Carey commenced her legal experience under the guidance of her senior, Mr. Damien Gomez, Queen's Counsel, and received extensive experience in commercial law, conveyancing, criminal law, and civil litigation. She has since ventured into the regulatory industry, being formerly employed with the Securities Commission of the Bahamas and currently serving as the Assistant Legal Counsel at Central Bank of the Bahamas. Among various accolades, notably, Mrs. Carey holds a member status with the Chartered Institute of Arbitrators and is qualified in anti-money laundering and compliance. Rebekah Ratliff is the founder and president of Capital City Mediations, LLC, which is a US-based mediation, arbitration, and consulting firm. Equipped with her dispute resolution skills and unique subject matter expertise, Rebekah has become a resource consultant for countless law firms interested in learning the value of their cases to determine the appropriate course of action regarding trial or the pursuit of dialogue geared towards settlement. She is a credentialed formal commercial insurance claims professional with more than 25 years experience in evaluating, negotiating, and resolving complex liability cases for global commercial insurance carriers nationwide, that is to say in the US, and internationally with settlements totaling in the millions. She is also a member of the American Bar Association and serves as the Diversity Committee co-chair of the Dispute Resolution Section. She holds positions with the National Bar Association as the second vice chair of the ADR Section and Advisory Board, and she's a member for the Small Firm Solo Practitioners Division. In January 2021, Rebekah was appointed as a JAMS dispute resolution professional, which is a arbitral institution located in Atlanta, Georgia. So we are going to get into the questions right now to start the discussion today. And my first question, and this is for any panelists who may wish to respond, what is the position of your respective organization in relation to the promotion of ADR in the Bahamas? Is there support for it? Or what are some of the concerns that your organization would have? And what are some of the suggestions you would have to correct some of those concerns? Anyone is open to responding to that question.
Ms. Nottage, if I may, I'd like to get the ball rolling.
Thank you, Kenia.
Thank you very much. The Chartered Institute of Arbitrators, we are, as far as I am concerned, we work as best as we can as a cohesive unit. We try to work in unity in terms to promote ADR through the following ways, of which you will see a number of our persons who are represented here today, which includes, of course, Mrs. Carol Lashley, a retired Justice Ruby Nottage, Ms. Sharice Brown, our education officer. And of course, within the audience, we also have various persons, which include Ms. Shellen Ingram, who's our second vice chair, Mrs. Kelphine Cunningham, our chair, Mr. Michael Digges, and our past chair, Mrs. Sharice Cox Nottage. Various ways we try to promote, which include the teaching of ADR, which is quite new. We signed an MOU with the Eugene DePuche Law School. And Ms. Nottage, I don't want to really put you on the spot, but you really helped to facilitate that. And that was signed on the 23rd of October, 2020. So we have a number of our persons volunteering with the teaching of ADR. So that's one form of promotion. The drafting and development of legislation, of course, that was touched upon, and we thank once again very much Chief Justice Sir Brian Morey QC. But we have certainly very capable senior members in the form of Mrs. Carol Lashley, retired Justice Ruby Nottage, Mrs. Kelphine Cunningham, Mrs. Bertha Cooper. So we have a lot of support there. In terms of the drafting of legislation, never forgetting Mr. Peter Maynard, who are our senior members. The Chartered Institute of Arbitration also seeks to educate. So we offer courses. And of course, my colleague, Mrs. Sharice Brown, Ms. Sharice Brown will elaborate further. We certainly had a webinar, which was quite recent, the 4th of December, 2020, where we had what we deem to be a general outreach to the public. And we'd like to, of course, thank Sir Brian Morey QC and Minister Johnson, who were our keynote speakers. We had a CARB Bahamas newsletter, which was under the auspices of our past chair, Mrs. Sharice Cox Nottage. We called it The Adjudicator. That was issued April 2020. And under our current chair, Mr. Michael Digges, we've had an outreach of a radio program. In fact, Mr. Digges hosts his own radio program called Blueprint for Change, where a number of our members were featured. And of course, through our marketing officer, Mrs. Doneth Cartwright, who's been working tirelessly and assiduously. We've been reaching out through social media, through our newspapers, yes, through radio. So we have been pretty busy in terms of the promotion of ADR. I would like to say, though, a number of concerns, perhaps, or things to be noted within our grouping that we'd like to just put out there is that we'd like more accessibility of ADR. I was very interested to hear what the Chief Justice had mentioned in terms of the early neutral evaluation. I think that's a wonderful first starting point. And so that's something that we are considering in terms of trying to make ADR more accessible to people where they don't really have to think about the issue of problem solving or dispute resolution. And of course, Chartered Institute of Arbitrators internationally is not just looking at dispute resolution, but also dispute avoidance. Areas that immediately come to mind, again, that the Chief Justice touched on, for example, construction adjudication, but of course, we've had issues with hotels, teachers, electrical workers, customs, airport workers, so the labor unions, issues of the environment. I won't go into that too much, but of course, maritime issues. And there's so many, many more areas that arbitration, mediation, ADR itself can infiltrate. So I hope that gives you a broad overview of where CARB is coming from in terms of promotion. Thank you.
Thank you for that, Kenia. I'm going to address my next question to Mrs. Lorna Longley-Rolle. I wondered if you can highlight the formal arbitration process at the Insurance Commission and the overall ADR framework that's been introduced.
Okay, the Insurance Commission is empowered by the Insurance Act under Section 20 to arbitrate disputes between policyholders and insurance companies. And as a result of that empowerment in our legislation, we formulated first and foremost a complaint review committee in about 2012 to review the disputes. It's our informal mediation process that we go through before we actually have an arbitration. In 2018, we introduced our arbitration rules, our arbitral rules, which are on our website, www.icb.gov.bs. And those rules set the framework and structure for arbitration in the Insurance Commission. Since those rules, we've had 2 arbitration processes at the Commission, which have been decided in favor of the policyholder in both cases. We went through this process. We went through this process in terms, the processes in terms of case management. We went through a 3-panel tribunal. We had terms of reference, and probably something we should say up front about our process is that there was no legal representation before our panel. This we thought was important because we did not want a policyholder to be in a place of disadvantage because they could not afford representation. And it was allowed by the Arbitration Act, where once the parties agree to no legal representation, there's no legal representation. And so we feature a lot of the principles and provisions that come out in our Arbitration Act. We feature a lot of principles that came out of the model legislation of the International Court of Arbitration. And we would like to say so far it's been very successful for us. In terms of promotion of ADR in Bahamas, we feel that this is something that can benefit the financial services in general. However, we know that we were mandated in our legislation to actually have this process. For concerns for us arising out of our process so far and promotion of ADR so far, one of the things I like to say is that the Commission has made the decision to bear the cost of arbitration for all of the parties, for both parties, both insurer and policyholder. And as a result of that, one of the concerns that we have right now is controlling costs. We did actually, our actual costs were within the vicinity of our budgeted costs. However, we are looking at that feature and looking at how do we best control that, because of course we are spending the public funds. Another concern that we have is right now is we're revisiting who qualifies as an arbitrator. Right now we have persons that have membership in local organizations as our arbitrators. And we'll probably put some more parameters around that in the not too distant future. One of the other concerns that we had was challenges to arbitrators. We are looking as to whether we should limit that to just impartiality and independence, or if we should open up that field as it now is, where there can be any challenge. And that is because in one of the cases we did have a challenge. So the commission has a formal structure for arbitration. It's worked very well for us, I should say. So far, we act as the secretariat. The panel is independent, and I think I'll leave further information for some of the other questions that you will have further down.
Thank you so much. Thank you so much, Mrs. Longley-Rolle. Now, I just want to put the same question to three other persons on the panel who I think it's important that we hear from. That would be Mr. Parker, Mrs. Rutherford-Ferguson, and Ms. Gibson. Could you also confirm the position of the Bahamas Bar Association, the Chamber of Commerce, the Securities Commission in relation to alternative dispute resolution and the use of the same, please?
As the other Ms. Nottage indicated, members of the bar have been for many years at the forefront of the ADR push domestically. As president, when I got on board, I felt the need to lend the institutional support to their efforts to sort of consolidate what seems to be sometimes disparate advocacy, and to sort of centralize it and create a more unified national position. And so to say that the bar supports it, I don't think that needs to be said. We have embraced, and we have been embraced by the Chief Justice in his reform efforts. And that has proved very instrumental to progressing more broad-based uptake among practitioners of ADR generally, and mediation and arbitration specifically. So we're in support of it. We are looking at the broad institutional structures to see how we can incorporate it as the Chief Justice indicated, as an adjunct to the judicial process, and as another means of practice for our members. I think that whether you're in arbitration, whether you're in court, the need and the role of lawyers is there. And so in that regard, we are facilitating our members who make a living in arbitration and mediation, who have an intellectual curiosity and interest in the area above that. So that's what I would say on behalf of the bar.
Ms. Gibson or Ms. Rutherford-Ferguson?
Okay, I'll just jump in there right now. Thanks, Leominic, for that question. With regard to the position of the Bahamas Chamber of Commerce and Employers Confederation, we are very much in support of the ADR process. And I think it bodes well that the Chamber has a policy and ADR committee. Many of the persons who appear today as panelists and even attendees for this webinar serve on the ADR committee. So we're quite pleased about that committee and the efforts that have been made thus far. With regard to where we see the Chamber playing a pivotal role, it's one where we've seen around the world that chambers are very involved in the ADR process. We are a member of the ICC, and the ICC, they have a robust framework for ADR. Not only that, chambers globally serve as a neutral place to have these disputes heard. And in addition to that, we see the Bahamas Chamber of Commerce being a mechanism to maintain a centralized register of qualified ADR specialists. Another thing I'd like to touch on is the fact that annually the World Bank produces a report called the Ease of Doing Business Index. And why I raise that is because one thing that's very important to the business community, and according to that global index, is the fact that the time it takes to settle commercial disputes, that's really important for businesses. So as we discuss ADR and the process and how organizations and various stakeholders like the Chamber can get involved, again, I see it as an opportunity for us to have these disputes heard in a neutral place, for the Chamber to facilitate and administer the ADR process, And we are very much in support of furthering this conversation and seeing where the jurisdiction goes as a hub.
Thank you so much, Mrs. Rutherford-Ferguson. Ms. Gibson, can you give us a very high-level overview of what the Securities Commission position is in relation to ADR or the use of the same, please?
Sure. Good morning. So, unlike the Insurance Commission, we do not have separate legislation addressing the issue of ADR. It has built into it several mechanisms by which the Commission can resolve disputes with its licensees and registrants outside of going through a judicial process. Having said that, we have not in our legislation said to persons that you cannot access the judicial process in order to resolve any particular dispute. Our process requires that if someone has raised a dispute with us concerning a decision made by the Commission, maybe on an application or a decision to withdraw a license, that we first go through our internal process of having the Commission review that decision. And the person who's aggrieved has the opportunity to be represented by counsel and to attend that hearing. Hearing panels, we statutorily are permitted to create hearing panels. And those panels are generally made up of 3 persons, 2 of which have to be completely independent from the Commission, and 1 of which must be a member of the Commission. And when I say member, I'm referring to a member of the board because the Commission is managed by a board led by a chairman. And so that process allows us to get to a point where we can resolve disputes with our licensees and registrants, either to arrive at a settlement, because most likely that's what we're trying to arrive at, a settlement to resolve the dispute. If someone has to be fined or penalized, that we can agree between us what the measure of that particular penalty or levy is. In terms of a formal process, I want to say that if you look at all of the elements that make up ADR, I think we probably use conciliation more than anything else, because we do try to avoid heading to the judicial process, which of course I think most people agree is very expensive and can be very time consuming. I mean, you can have matters dragging for very, very long times. And for the purpose of a regulator, you cannot have a matter that's dragging for 3, 4, 5 years, because the particular issue that must be resolved needs to be resolved probably quickly, because it may affect other licensees and registrants. So for our purpose, we try to use our internal mechanisms to arrive at settlements prior to anyone deciding that they're going to free to do so, and we will of course address it as it arises.
Thank you so much, Ms. Gibson. Mr. Bowe, as someone who has their finger on the pulse of the business community in the Bahamas, I wondered whether you can give us a very high level overview again, or somewhat of a temperature check on the attitude of the business community to ADR, and whether you think that persons in the business community will be more amenable to using alternative dispute resolution as opposed to traditional court proceedings.
Money talks and time is money. And so what you find is having avenues to efficiently resolve disputes that are involved in high stakes finance. The Bahamas is also an international financial center. And from that perspective, it is very important that we are not only holding ourselves out as being high quality, but have the mechanisms that allow us to effect that. A lot, I'm sure the Chief Justice would attest that the civil matters involve financial intermediaries, whether they be direct financial institutions or parties within a particular transaction, commercial transaction, because invariably it is over interpretation, invariably it is over who's going to bear costs and responsibility as it relates to a particular commercial entity or transaction. And so I think from that perspective, certainly the business community in general is always going to be supportive of having the most efficient dispute resolution mechanisms available. Equally, regulated entities would welcome, as was said on the Insurance Commission, and certainly with the other regulators, having that mechanism in place to sometimes more effectively resolve a dispute that may require greater expertise. I think it is well respected that the court system engage the professionals involved to get to the right answer. The alternate dispute resolution mechanism allows almost direct interaction with those who are chartered as arbiters and will have the ability in order to execute and carry out such dispute resolution. If we were to say challenges that we would want to overcome, it is making sure that if we're in for a penny, we're in for a pound. That ultimately that we are ensuring that as a jurisdiction that we move with haste to ensure that the mechanisms infrastructure is set in place so that we can hold it out, not only with one, the actual appropriate legislation, two, the appropriate professionals that would be available to carry out these types of mediation and arbitrations, but three, also the ability to have speedy turnaround in terms of when decisions are made and be very transparently communicated. So I think that it is well respected and well accepted amongst particularly the financial institutions and business community that any efficient dispute resolution mechanism outside of the courts, with all due respect to them, is one that is welcomed by and will be supported, as I said, by infrastructure as well as its utilization.
Mr. Bowe. Now, I recognize that the regulators that are on this panel all seem to be in support of ADR as a viable alternative to traditional court proceedings. We also have the Central Bank of the Bahamas represented on this panel. And I wanted to put this question to Mrs. Woods-Carey. I'm wondering whether you can tell us a bit more about the financial ombudsman proposed for the Central Bank of the Bahamas.
Good morning, everyone. Okay, so the role of the ombudsman is one of the tenets of the ADR spectrum, and it is a very important function in the ADR process. However, the financial services ombudsman role, while being quite similar, where it facilitates the resolution of conflict, it will not solely be based on ADR functions. Now, the bank is tasked with maintaining economic protection to its consumers, and this is apparent through our legislative framework. So in keeping with consumer protection, the bank is currently in the process of recruiting an ideal candidate for consideration of the role of financial services ombudsman. And having this independent person in place, we believe that the role will strengthen the confidence of consumers, and it will invoke more accountability from the financial institutions. Also, the ombudsman will review as well as recommend new and comprehensive regulations where needed to ensure that the consumer needs are being addressed. So in keeping with this role, this independent person will serve as in a public-facing role within the bank. And this person will be responsible for investigating and resolving conflicts, complaints, receiving complaints about licensing issues which are based on the financial institutions that we supervise. And so the ombudsman, once selected, will assist in establishing an office of the financial services ombudsman, and his or her supporting staff they'll be responsible for ensuring that complaints are disposed of in a fair and favorable manner. This person will also be the point of contact for improving public understanding of issues related to complaints that are coming in and consumer related. Also, the Financial Services Ombudsman will be the liaison officer within the public, financial sector regulators, domestic as well as international financial services institutions and organizations, governmental ministries, professional bodies and associations. They will liaise with all of those associations. And the establishment of the role within the bank will certainly will be expected to result in swifter resolution of complaints, as this role will be primarily focused on interfacing with consumer needs. Are there any other question concerning this role?
I haven't seen any questions come up in the Q&A function, and I don't have any additional questions for you in relation to that role. I wanted to move on to consulting opportunities and to put some questions to Ms. Ratliff on that. And I wanted her to give a little insight in the course of 1 to 2 minutes in the interest of time, just to confirm or indicate to us how have your consulting opportunities come about, whether you think a person has to have a legal background in order to be an ADR professional, and just indicate how did you get into the ADR field and what you think the importance of ADR is for the Bahamas and for persons internationally.
As a former commercial complex insurance adjuster, I was the policy contract analyzer, investigator, evaluator, and negotiator in claims loss matters in the US and globally over my 25-year career. So I had developed a very unique skill set as a non-lawyer, and it wasn't hard to reinvent myself as an arbitrator and mediator. The challenges that I faced initially were mainly relevant to not being an attorney, but I learned to market myself and really in a white male dominated field, both insurance and legal. And my work in insurance, though, what I realized is that it prepared me in a variety of subject matter areas: personal injury, wrongful death, auto and trucking, commercial premises liability, products liability, nursing home liability, construction, and a variety of other areas. So I realized that my subject matter expertise that I was able to amass in that 25 years enabled me to add consultant to my title. The consultancy title came from a mentor of mine who said, well, you're a case evaluator. So I really enjoyed hearing early neutral evaluation. That's the consultancy piece of my business. I'm with JAMS, the Judicial Arbitration and Mediation Service, which is, can everybody hear me? Somebody's put in the chat, you can hear me? Okay, all right. I just happened to catch that. So JAMS is the largest private provider of arbitration and mediation services in the world. And what I came to figure out is that by leveraging my body of work and my knowledge, the part that was the original challenge became my secret sauce. And so I've learned, as you depend on your network, build relationships, you get discovered in other, as some of our colleagues in the US, COVID and the other challenges worldwide have shut down the court systems and slowed everything. And so mediation and arbitration to some extent is the only access to justice for areas where people are not able to sit on juries. The disparate advocacy that one of our colleagues mentioned, mediation and arbitration is an alternative access to justice for many. And I do want to put in a plug for early neutral evaluation. As a non-lawyer, my clients value that I was never a legal advocate. So that makes me a more effective neutral. I'm naturally a neutral, and I have the subject matter expertise from my master is subject matter expertise, and with the blessings that came from the hard work that I did, ended up being a real benefit to the ADR profession. And again, I'm the second vice chair for the National Bar Association, so I would love to speak further at another time about how the National Bar Association could possibly partner to put the Bahamas on the map the way you want to be.
I just have one more question, and I want to put this question to Mr. Parker because I know he has extensive experience in employment law. So one of the questions that we got ahead of time by one of the participants is, how does the panel envisage ADR being used in the workplace to support employers and employees, and what impact might this have on the work of the industrial tribunal?
Well, yes, that is a significant area of my practice. What I'll work backwards, the work of the industrial tribunal, the first point of engagement that you have domestically when you have a trade dispute, the only way that you get to the industrial tribunal is through a conciliation. You report a trade dispute and you are summoned to by the Director of Labor to a conciliation hearing. And there you sit before a conciliator and an attempt is made to find some common ground and resolve the issue at hand. The increased focus on ADR and ADR training is very important because it assists us in supporting the conciliators, supporting the staff complement at the Ministry of Labor who do that work. And it also increases familiarity with the subject on the side of the employer and the employee, who sometimes come to these things and look at each other and say, you expect us to talk? And so it's very important that you educate people about dispute resolution, and that it's not always a zero-sum game. In the workplace, I think that it is that has to be a product of the employer outside of the unionized environment, of course. The employer determining what is in the best interest of resolving internal disputes, somewhat allied to the human resources function, and internalizing that and training their professionals to handle conflict and handle disputes internally so that it doesn't escalate to trade dispute level. In terms of the relation between unionized workers and the employer, it is very, very important that the human resource function and that the management function is as in tune with dispute resolution and alternative dispute resolution as possible. Because if you don't approach it with good faith, then really you know all roads lead to the Supreme Court if you can't engage with people in good faith in terms of embracing alternative disputes. So I would say that it is very important as we navigate industrial training and engaging staff that are trained in helping to resolve disputes and bring them to the table in a healthy and positive way. So I would say that is where I see things going, and I think that there is a great need there. One of the things that we're working on as a bar with the National Tripartite Council is strengthening that conciliation, that mediation function at the front end to avoid matters that ought to be resolved amicably progressing because people are not engaging as they should with the process.
Thank you so much, Mr. Parker. And again, thank you to each of the panelists on this panel.